Good morning, good afternoon, or good evening, everyone. Welcome to the fourth and last panel of this webinar series entitled Empowering Perspectives, Unpacking the Brazilian Industrial Property Law. Once again, I would like to thank you all for virtually coming, especially those of you who have been attending this webinar series for the past 4 days. Thank you. I would like to thank as well the Young Scholars Initiative for supporting the organization of this event through the Finance, Law, and Economics Working Group. And also, I would like to thank Future Law and LAP FRJ as co-organizers. This webinar series is based on the book Comments on the Brazilian Industrial Property Law by Woman, recently published by Thomson Reuters in Brazil, which unfortunately so far has only the Portuguese version. So therefore, this webinar aims to bring some of these women together to talk about the Brazilian IP scenario in English language for national and international stakeholders. It was the first time that we had such a piece of work authored and organized by women in Brazil and maybe in the world. And therefore, it is also the first time that a webinar series is exploring and following this path. Today, we are going to discuss Brazil Beyond Borders, as the title of the panel is Beyond Borders, Navigating IP Agreements and the Territoriality Principle. I am Deborah. I am IP and competition lawyer. I hold a LLM in law and economics, specialize in the economic analysis of IP and innovation at the Erasmus University Rotterdam, Hamburg University, Ghent University, and Pompeu Fabra University. Together with me, also moderating this panel, we have the pleasure to have Deborah Sichel. Deborah, would you like to introduce yourself?
Yes, thank you very much, Deborah, for the invitation. It's a pleasure to be here discussing this book. Let me show the front page. This one is very interesting, very rich. It's about the law, which was edited in 1969. So there is almost 30 years. And now we have the chance to discuss it with a woman view. I am professor, assistant at the Universidade Unirio, Universidade do Estado do Rio de Janeiro, and at the CEDERJ, que é um consórcio de universidades públicas do Estado do Rio de Janeiro for commercial law. And I am postdoctorating at the UDS, Universidade de Desenvolvimento e Sustentabilidade in Chile and Paraguay. And I am also a lawyer at HNS, Hanevald, Natividade and Sichel Bureau, né? So, and I'm very glad to be here to present the Karin Klemp-Franco, who is going to talk about the tributation in paying intellectual property in Brazil. Thank you very much for the invitation, Deborah.
Thank you, Deborah. All right. First, we start with the discussions. I would like to introduce to you all the agenda. As you may know, we will have 15 minutes to each discussion. And then with the remaining time, we will be taking questions. So please write down your questions through the chat here on the platform during the presentations, and we will read them timely. That said, I would like to introduce to you the first speaker of the day. Her name is Thais Castelli. She holds a PhD and master's degree in International Economic Relations Law at the Pontifical Catholic University of São Paulo. She has developed her career as a legal manager at Brazilian companies such as Natura and Sadia, dedicating herself to the internationalization process to extract her business abroad. And nowadays, she is a partner at Castelli & Castelli, a law firm for international legal assistance. And she's an adjunct professor at the Getúlio Vargas Foundation University in São Paulo, where she teaches MBA courses. She authored several books and articles on IP. And Thais, the floor is yours. Thank you very much for being here today with us.
Thank you, Deborah, for the invitation, and thank you all for being here with us. And many thank you, Carrie, for sharing this panel with me. Carrie is a friend from high school, so it's really a surprise to be sharing this panel with her. And so let's just start the presentation, otherwise I will not have the 15 minutes anymore, and much less than that. So I will try to speak as much as I can in just like short period of time. And I prepared a presentation, so I will share with you. And then just afterwards, feel free to make any questions you may have. So, and this is the initial part that Deborah just shared with you. That is my resume. And I continue here. And those are the two books that I published regarding it's a single approach about the territorial principle in IP law. It's actually my formation and my area of my professional area is most more related to internationalization of companies. But on the past, I started to have a special motivation to just enter into the field of intellectual property law. And I started to really be enthusiastic of this subject matter. So it ended by by having a result, those two books that I published that are the results of my master and PhD studies. But what drove me to those studies were much more the issues that I was having as a lawyer. So I was working PwC at that time, and I faced a lot of difficulty in structuring business of like foreign companies in Brazil, because they always faced the issue of like a lack of protection in the territory that really had the consequence of postponing or even restrained their entrance into Brazil. So they faced that issue of needing to protect the IP law in Brazil while they have not protected before, and that compromised their business in the country. And this really was something that I could not understand at that time. And then I started to study that in the master's degree, and I had a very good professor. His name is Guzmão. He's in a law firm just dedicated to IP law, and he was the person that followed me in the studies. And at that time, I wish I could, and I wanted to write about the global protection of IP law, but he said, no, you have to write things as really are in the law itself, that is related to the territoriality of the protection. So that was why I had to write the first book. But after many years, I came back to him and said, now I can really, and I want to write whatever I feel that I should to try to reflect and instigate the institution to a broader protection. So those are the results and what is behind those two books. And that was the most recent one that was published just this year. And then I wrote one article that brings some of my studies to a specific article that I write about the initial articles of the IP law, that are Article 3 to 5, that are related to the internationalization and territorial protection. Well, having said that, I just start to give you some insights. The reason is not like to go deep into the concepts, but instead to give you some ideas. Ideas of what, I'm just shorten that because I cannot see really well. Ideas what is behind the concepts that I brought to my studies. And so the first one is like, when we see that word, is like, it seems that the word itself has no boundaries, there is no frontiers. And most of my students nowadays, they work in the international market and trade, international trade itself. So when they look at that, it's really easy to see that the products really flows from one country to the other very easily. But when we see that under the legal perspective, we do have restraints, we do have a different structure. That is why the law is structured like that, coming from the structure of the states itself, that brings frontiers and that does not allow that flow into the international market as we perhaps would like. So bringing that to the legal structure and real world where we are now in terms of traditional studies, we do have to talk about the state itself to think about the protection. So how does this word is structured? And then the answer is in state structure. I mean, monopoly of the state jurisdiction, which brings spatial limits where the state can rule and can really structure the conducting of activities into its territory. And that territory is the territory where the state has sovereignty and power. So the same territory physically saying that he has the power is the territory that he can pronounce, he can really enact laws that has just spatial limited and cannot go abroad. So the world is divided into a state, and each state has the power to rule the actions that happens into its territory. That is how we studied in law and how the word is actually structured based on this central power of the state. But at the same time that the state has this sovereignty prerogative of power, the state has functions and duties. That is to render to the citizens the judicial order and to coordinate inside its frontiers the actions. And these functions, when we bring that to IP rights, it says that the state has the duty to, by an administrative act, to grant protection of IP rights. So the acquisition of the property, the acquisition of the protection itself, it comes from the state by the Registry Act. And the only space that the state can really pronounce and give the property is the one that the state has power to rule. So we start to connect the territorial principle to the same territoriality that the state can act, that is the territory of the law. So in IP right, we're gonna see that the territoriality principle of IP right, it gives the same space that the territory of the law. The extension of the right, the exercise of the right, or say the extension of the protection is also the same territory that the state can rule, that is divided by frontier. So this is where, how it's structured and where the IP principle comes from the structure of the state, monopoly of the jurisdiction, being that the only territory that the state can pronounce, can enact acts. So this gives a limit of the protection, a limit of the acquisition of the property itself. But going beyond that, we do have this principle that we're going to talk now and resume what it's about, the territorial principle. It's nothing more than a connection element, and it comes from the nature of a private international law's rule. It's a principle that comes from the international law itself. It's not really a principle of IP law. It organizes among possible laws that would apply. It says that the law that applies for the acquisition of and the protection is the law of the state. That is the one that the individual requires the protection. So the IP, the principle, the territorial principle in IP rights I mean, now in trademark and patents, it's nothing more than a principle of international right, international law. So it rules and it organizes, it connects the law of the state of the registry as the one that applies for acquiring the property and ruling the dimension of the protection. And so it limits naturally the protection to the state that really has the power to enact this administrative registry to really grant the property to the individual that is required this property. And that is what I have written here. This principle, it limits the protection of these assets to the territory of the registration. The property itself, the ownership, the legal existence of the asset, and at the same time, the extension of the right. So there are two things here connected: the acquisition itself, the ownership, plus the dimension, the extension of the right that can be exercised based on the protection itself. And at the same time, what is really important here is that also this principle in the way it's structured, it does not allow the application of another international principle that is normally seen and applicable to assets itself. In other words, it does not recognize the legal situation, the property or the ownership acquired in other territories, which means does not recognize the vested right or direito adquirido in Portuguese. So it limits itself that the property, even though another person has acquired the trademark property in another territory, has the acquisition of it by means of another registry abroad. If it wants to use that property in Brazil, it will not be able to as a right because it has not acquired the property here by means of the registry, because the registry itself is an act of the state, and the state is the one that is allowed to really grant the property in its frontier. And at the same time, it does not recognize this property acquired abroad. So this is how it's structured, and it has a consequence, as we know nowadays, and we use the one that acting IP right often see that as a consequence, as a result of the territorial principle. That means there will be different national protection system, because once I request the protection and the property in different states, it means that different legal systems will apply to the same assets, to the same trademark, to the same patent. So we will see that the same assets, the same trademark will have different rules based on the legal system that apply it based on the registry that has been requested in many different states. So that is a reality that we have to face. At the same time, there will be many registrations depending on the place on the country that the particular, the company or the individual itself wants to do its business. So we will deal with a coexistence of ownership of, different register of the same owner, but at the same time, the same trademark can have different owners based on the request of protection in other territories. If the one that has originally requested the trademark in one territory has not protecting the others. So the not protection in other territories allow third parties to request and have the property in different countries at the same time. So the same trademark can have different owners depending on who has requested and where it has requested the registry. So this is how we see nowadays when we act in IP rights. This is reality that I'm bringing here that comes from this in the territorial principle. And at the same time, we are going to have independence of trademark and patents, which means if I have a trademark in Brazil and a trademark registered in Germany, there is not going to be a connection of those registers. They are completely independent. If one is canceled, the other one can remain valid. So there will be independence of those registries. So those are all facts related to the territorial principle in IP rights. And at the end, we have raised an issue related to the limitation of jurisdiction stricto sensu, which means that the state of acquisition where I have request, the state that has granted me the property, the ownership, is the one that is competent to deal about the IP right itself, the asset itself, regarding ownership, validity, etc. Everything is related to where I have original registry. Except if we're thinking about infringements, that there is a relative competence. So if a trademark that I have registered in Brazil is infringed in Germany, and then we are going to have possibilities of requesting that right in other territory, in this case, in Germany, bringing the existence of the trademark from Brazil, but with the infringement there. So there would be somehow a relative competence, but this is where we are nowadays in terms of challenging if we bring that to the digital world. So just, I think some more minutes. I'm gonna go from that principle to from that traditional way of protecting that principle to some issues that we are facing nowadays regarding challenges of the protection due to the digital era that Asia, and also to the network, the internet itself, that has been bringing some issues that we have to think about and see how we are going to deal with that in terms of having the so desired protection. So what is...
we already active 50 minutes, so maybe can we conclude in 3 minutes?
I have 2 minutes, Nora.
Okay,
I'm just
perfect.
ending.
Okay.
Just to bring you just other view of protection. And then we have nowadays new technologies, a transnational environment, co-creation in that environment of networking and new dynamics that are happening in just different instrument of connecting people around the world. That is the technology and internet itself, with the interaction of people in co-creation, open innovation, software, word sourcing, Creative Commons. So there's a lot of that new dynamics occurring in this new environment and in this transnational environment itself. So how can we talk about territoriality when the things are transnational by itself, and the support, the internet, is a international way of dealing and interacting with individuals and producing rights? And so how do we deal with that, comparing to the rationality of the territoriality that comes from the state itself? So there are rights producing there, and then we also have to deal about the balance of other rights, like rights of access, of information, knowledge, technology, universal culture. So how we balance the privatization of protection versus also all those other rights that are all inherent to what is happening in this new way of doing business, that is the digital world. So a way to, so last slide, and a way to deal with this new scenario is to think about law differently. So law, not more a authority, a way of imposing authority and as a monopoly of jurisdiction, but a law that mostly it gives a conduction of conducts a code of conduct itself, not an act of enforcement. It rules, it has compliance and solve conflicts and gives conflict settlements, but in a different rationality, in a different concept of the law itself, not a law that comes from a state that imposes the right, that has authority, that has sovereignty. There is a new dynamic about that, but there is law at the same time, and there is regulation, there is organization, there is compliance, and also we produce decision in this new way of thinking the law. But how can we do that in this transnational way, in this national environment, if we go out from the state? So we are bringing here the possibility of having this law enacted by other authors that comes from private sectors of the society, and that produce law itself, organize the environment and organize the relationships, the new dynamics. And it's really authors that we can trust that a decision will be made. Comparing to the state that we know that there is a lot of functional problems as well. So it's going out from the monopoly of the jurisdiction, accepted the pluralization of the legal system by bringing other authors. And here I mention international organizations, private institutions, institutes like multinationals, Chamber of Commerce, and also the agreements that are produced among individuals and companies. So those are instruments and authors that are producing law and that are really effective. And then we need to give more importance because they by themselves have a way to act in this transnational environment, not being limited by the territory. Otherwise, we're going to continue talk. What is the law that applies? My law, the law of Germany or of Netherlands, etc. And my right on my asset is limited to Brazil, to Germany, etc. So the idea is that those international organisms start to produce IP rights, give up IP rights ourselves. Why not? We have OMPI giving the registry of patent. That is a global protection by having this international organization that can be independent from its member, but at the same time producing and ruling by administrative act, giving protection of this IP rights to individuals and companies. So we change a little bit the way of thinking the law to add this new rationality and applying that to IP law and IP rights itself. And this rationality does not means that the state is going to be apart from it. The state continues to be part of it, but with a rationality of cooperation, integration, integrity of all those authors that produce the law towards a way of trying to bring a universality of a protection with coexistence of different orders. So it's a way to think differently from what we have nowadays. And at the end, I brought the answer to the questions that we were kind of instigate to bring, but I'm not going to, just one second, Evan. I will not going to answer the questions now, so I leave that to the debates. But we received those questions, and I did an exercise to bring answers. So if you are curious, or if comes to the debate, I can bring specific answers to those questions. Thank you, and sorry for being late in the presentation.
Thank you, Thais. Thank you. Now I would like to pass the word to Deborah, so Deborah can introduce Karin, and then we can continue.
Thank you very much, Deborah, for the opportunity to talk to internet. There are so many people there, no? It's a pleasure to be here, as I said already, and I'm present Professor Karin Klemp-Franco. She's a professor in São Paulo, doctor in commercial law in the University of São Paulo, has the Magister Legum in the Universität zu Köln in Germany. She has postdoctor in domain names. She's a lawyer in Barcelos Tucunduva Lawyers, and She is professor in the FACAM, Faculdade de Campinas, né? Campinas faculty. So, and she's going to talk about royalties and INPI, né? Our place to registration, intellectual property rights, and the flexibilization of the tributary law. So it's your turn, Karen. Thank you very much for being here.
Thank you very much, Deborah. Well, first of all, I would like to thank the other Deborah Vicente for the invitation to be here and congratulate you as well on the initiative. I think it's very, very fruitful and interesting, and it's an honor to be here on an international basis for an international audience. And Professor Deborah Zichel, Lars Zichel, thank you very much for the introductions. It happens to be a little bit old, the description of my CV. I'm currently a partner at Cassione Advogados, which is in São Paulo. And I am a doctor in commercial law and a master of law by the University zu Köln in Germany. And I am, regarding domain names, I am a specialist, a panelist for the resolution as a type of ADRs, as arbitration and mediation as well. Those are areas that I practice a lot. But switching into my topic, I wrote about Article 211 of the Industrial Property Law. And this is a very peculiar article of the law because it's not common anymore in other jurisdictions around the world. This used to be a common practice in Latin America and other developing countries to have transfer of technology agreements registered by the local patent and trademark office or industrial property office. But nowadays, as far as I know, we only have Brazil and Philippines with this kind of requirement. In any event, Article 211 is still there. It deals with the obligation to register any contract that involves transfer of technology with the Brazilian National Institute of Industrial Property so that it's effective against third parties. And then we start the discussion on what this means, what's the sense of the law, and what's the ruling. And traditionally, when we take the law that created the Brazilian National Institute of Industrial Property, this law conceived INPI the function of ruling transfer of technology and also to rule on industrial property according to the social, technical, and commercial function of industrial property. So it's a very broad term. In order to interpret this, we need to research a little bit more and see what was meant by the lawmakers. Curiously, a few years later, when the current industrial property law has been enacted, which was in 1996, as Professor Laxicho pointed out, we had an amendment to the law that instituted INPI. So the part of the article that ruled on INPI's attributions related to the ruling of transfer of technology was taken out. But we still have the part of the article that deals with the social, economic, and technical function of the ruling of industrial property by INPI. So, historically, how has been transfer of technology agreements, how have they been ruled inside the Brazilian territory? They have been ruled even before the INPI was created by international exchange legislation regarding to the remittance of payments abroad, and they have also been ruled by the tax legislation. And what happened at that time, and these laws that still apply until the end of this year to these agreements, they have been being enacted since the 50s. So it's a very old legislation that has been enacted with a very specific function, which was to hinder the remittance of royalties from Brazil to abroad, because it was understood that the import of technologies was being used as a means of disguise so that subsidiaries of transnational companies could remit those royalties abroad as a matter of disguised transfer of profits. So, this legislation aiming at making a dual wave in the exchange controls what enters the country from abroad and what leaves the country in terms of payments, and aiming at reducing payments made from subsidiaries to mother companies, was the spirit of the regulation on transfer of technology agreements. And then after some years, around decades of 70s, 80s, we had INPI registering these agreements as a condition precedent for these agreements to have payments authorized to be remitted abroad, and applying, according to its interpretation, tax legislation and currency exchange legislation. And in addition to tax and currency exchange controls laws, INPI started developing its own views on the transfer of international technology to Brazil. And these views were very harmonized with the rest of the position in other Latin American countries and countries from the Andean Pact. The view was that the importation of technology alone, only through a license, does not produce, does not foster technological development to the country. So, what all these countries started to make was to change the agreement and impose certain clauses in the agreements to make sure that the technology stays in the country after the term of the agreement has elapsed. So this was a form of making the transfer of technology effective, an effective transfer as opposed to a license. This was very questioned, and I think this comes from a specific reason. As countries that are under an industrialization process a little bit later than other countries, Latin American countries needed to innovate in the forms that they would acquire the technology. Because the first countries to be industrialized, like the United Kingdom, like the United States, like even Japan, they formed their industries in a time when intellectual property was not in place, or intellectual property rights were not in place in such an efficient way as we have nowadays, or in the decades of 70s, 80s, and 90s, where we already had the Parents Union Convention, the Berne Convention, the World Intellectual Property Organization, or OMP, that Thais brought here. So the first countries to be industrialized, they used the copy. They simply copied technologies from other countries, from other spaces, because they were allowed to do so. Now, the less developed countries, which is not the least developed countries under the TRIPS agreement, they are in a position that they cannot simply copy, unless they do not adhere to the TRIPS, to the Agreement on Trade-Related Aspects of Intellectual Property Rights, which is one of the pillars of the World Trade Organization. So the way that they found to discuss issues on transfer of technology was on their own, because this could not be agreed anymore under the Paris Union Convention. The audience of the Paris Union Convention wouldn't agree on a discussion on transfer of technology. And if you go to the TRIPS agreement, the article you have on this is Article 40, that says that the countries are allowed to impose limitations on license agreement clauses that limit competition. And in the text of the TRIPS agreement, which came much later than the Paris Union Convention, you have many exceptions of best efforts related to technology transfer, technological development, fostering of innovation, and so on. So those were exceptions that were negotiated by the agreements, but the countries could not find a final position as to how this transfer of technology would be fostered. There was an attempt under the auspices of the United Nations Commission on Trade and Development, UNCTAD, and the countries developed there the TOT code, the Transfer of Technology Code, to bring here something that Thais brought to us a little bit earlier, which are these codes of conducts. So there was an attempt from less developed countries, and this group of countries were under the leadership of Brazil and India. There was an attempt to implement a transfer of technology code, which was a code of conduct. If you go to the internet, you can Google it, you will find the text of the TOT code, aiming at fostering transfer of technology so that the less developed countries could have a better development of their technologies. But this TOT code didn't go further. It was not incorporated under the Paris Union Convention, and it appeared in the TRIPS under best efforts or very vague clauses. So this is the position that we have nowadays. We have the possibility of ruling these agreements. We have the possibility of INPI reviewing these agreements and saying what he thinks on restrictive clauses for the industrial development of the country, but also have a great pressure from more developed countries in the sense that this kind of intervention is not welcome. Brazil is not a country that is used to going into bilateral investment treaties. But if you go to some bids currently in place, you have the obligation that the country receiving the investment does not impose limitations on the permanence of the technology inside its territory. Exception made to competition rules imposed by a court. So this is quite the issue we have right now on the transfer of technology. What has happened in the last year, and coming to the end of my presentation of my 15 minutes, we had last year a revolution on this currency exchange rules. We have new rules ruling the role of Central Bank of Brazil on the limits of remittances and exchange operations. So the agreement's registration with the National Institute of Intellectual Industrial Property is not a precedent condition for the remittance of royalties abroad anymore. And this is already in place since 2022. And as of January 2024, we will have the substitution of all rules dealing with deductibility limits for tax purposes of royalties by transfer pricing. Transfer pricing is a pattern, is a standard that has been instituted by the OCDE. And what we have been watching in Brazil in the last years, not only in the intellectual property or tax areas, but in all areas, like privacy, where I also work with, and anti-corruption, is a very big effort from Brazil to adhere to OCDE rules. So all this is for effort on transparency, on having laws that are more harmonized with the rest of the countries of the world and so on, is a response to this attempt from Brazil to join, to have access to OCDE. And this is what will happen, not the access to OCDE, but how things will be ruled as of January next year. Completely OCDE compliant. Transfer pricing for IP license and agreements, including transfer of technology, and no exchange control rules anymore. In this context, INPI and the president from INPI and the authorities from INPI suffered a very, very strong pressure as to the role of INPI when reviewing the agreements and changing the clauses of the agreement. And as of September, or as of this year for sure, we have a new ruling enacted by the National Institute of Industrial Property, saying that INPI will not review contractual clauses anymore. It will only review the status of the industrial property rights, but it will not interfere within the will of the parties when negotiating this agreement. So this is the situation that we have right now. Article 211 is still in the law. It was inserted in the law as a matter of public policy, industrial policy, to foster transfer of technology to Brazil and help the technological development. We have never had in Brazil a specific industrial policy or intellectual property policy coming from the government, in this case, the Ministry of Economy, because our National Institute of Intellectual Property is under the auspices of the Ministry of Economy, not of the Ministry of Science and Technology. But we have never seen a ruling of these powers from INPI, but actually a development internal from INPI as how to rule this. But right now we have this emptied power from INPI coming from the INPI itself, a ruling from the presidency. We don't have tax limiting legislation anymore or currency exchange control legislation. But we still have Article 211 in the law. So it's up to the scholars, it's up to the industry, it's up to the government to decide which destiny will be given to the transfer of technology agreements and to the rule of IMPI when registering this agreement. So thank you very much. And this is the message I wanted to give to everybody.
Thank you, Karin. Very interesting, the contracts that Thais and you just brought to us, because, for instance, Thais brought to us the necessity of implementing a global framework for protecting IP rights. Meanwhile, you just told us that, for instance, for technology transfer contracts, the Brazilian Patent and Trademark Office still applies a very old rule. So it's a very interesting contract. I would like to move to questions. And I know that we are already passing our time, but we had a question coming from the audience, and it's not much related with the what we just talked about, but in a sense it is, because it is international, and it's also to think about how to go out of borders. So I would like to bring to you Karin and Thais, and then we can maybe discuss together. Ganis is saying that he is working in a research about profit shifting. And for profit shifting purposes, IP can be registered in a shell company, what we will say like a empresa de fachada, in tax havens, in paraísos fiscais. So how are, his question is, how are the IP laws in tax havens differ from the ones in normal territories? So I think this is a very interesting question, and I would like to leave the floor to you to us discuss more about it.
Would you like to start, Kari?
For me, it's the same. Would you like to start, me?
You can start, and then I add.
Okay.
Or whatever,
well,
if you want, I can start.
Okay, Gans, if you want to, I confess to you, I don't know, but this is something you can research. If British Virgin Islands and other tax havens are a part of the TRIPS agreement or of the Paris Union Convention. But what we see internationally is that these agreements, starting with the Paris Union Convention that impose the obligation of a national treatment to all companies coming from other countries, and the TRIPS agreement that impose an harmonized standard treatment and pattern of protection of IP rights to all member countries, using these two international agreements and assuming that a country would not be in less protection than what's obliged to, I would say that if those countries have adhered to these agreements, you don't have a much different situation as to the protection of IP. This to say that I would research more under the tax legislation of the other countries. For example, in Brazil, you have very, very heavy rules on taxation on tax havens. Transfer pricing rules also have very important exceptions. And then I leave the word to Thais, which I think it's her field.
No, I would go to the same sense. I mean, first, if we think about the traditional protection by state, that we goes to that always as the first idea of IP rights protection. You have to see what the local legislation say, and the first step is to say if it has the same standard, being part of the treats, as Karin said, the Paris Convention and the TRIPS Convention to see if you have somehow a common protection in just like based on those conventions. So this is the first step. However, you also have to think if you want to use that IP only in this place, or if you want to have to register it in other countries as well. So this is a politic. You have to think about a politic of where to protect this IP right, not just only in one country, but perhaps if you're going to use, etc. That is the same thing that we have been always talking, and when the limitation of the territorial principle that requires you to protect your IP right in other countries, and then meeting the local legislation of those other countries that you're gonna register this IP right. So this is the first thing. And also, as Karin said, if you are in tax haven and you're gonna make transactions from there regarding this IP right, you're gonna be in contact with companies in other countries, and the other countries restrain business coming from tax haven countries by means of taxing and more at those countries to try not to incentivize this profit shift that you said. So you have to think about the business itself, where you want to use, and at the same time to think that where you're gonna transaction, the country that I'm gonna transaction with have any restraints in terms of making business with a company in this country that would imply in a burden in terms of taxation.
Thank you very much, Karin and Thais. Now we have exceeded already the time limit, but I would like to ask if Deborah would like to address any questions.
Thank you, Deborah. Yes, I have a question, and it's for Karin. And I was thinking about the franchising law in Brazil, which is a new one. And does you think, Karin, that the new law of franchising doesn't oblige the registration anymore in the contract of the franchising in the National Institute of Intellectual Property? Do you think that this contributes to turn the Article 211 useless or out of order? Is this a sign that make this article useless? What do you think about?
This is a very good question, Deborah, and thank you very much for that. Under the old franchise law, we already had seen a totally not registration inside the Brazilian territory of local franchise contracts with INPI, although Article 211 expressly says that it relates to transfer of technology and franchise agreement, because there is a know-how component in the franchise agreement, which is very important, and the franchise agreement is a kind of transfer of technology agreement. But before the law changed, or until now, because the law will only change as of 2024, there was a big discussion whether the registration with INPI was a condition precedent for the party to deduct as business expenses the royalties that are being paid under the agreement. And the less conservative approach has always been in the sense that if you have an international agreement, royalties must be remitted abroad. Yes, you need to register with INPI, or else the currency exchange legislation will not allow you. No bank, no commercial bank will do the exchange transaction and remit the money. But if you have a national agreement between Brazilian entities, no, And this was the absolute practice for all franchise agreements between Brazilian entities. There's no Brazilian franchise agreement registered with NPI as far as I know. But the international, the master franchise agreements, yes, always they needed to be registered. Right now, with the change as of January 2024 of the tax legislation, and with the change that already occurred on the currency exchange legislation, it's probable that we'll come to a discussion or maybe to very aggressive positions from the companies in the sense that international master franchise agreements do not need to be registered with the NPI, even though they are there in the law. I can imagine that, and I would certainly think a lot if I had an international client, which is a master franchisor, and I needed to discuss with him whether to go to NPI or not.
Thank you very much, Karen. Unfortunately, we don't have more time for questions. We will need to close the panel now. And with this, we will close this webinar series. I would like to thank you very much all for attending. And I would like especially to thank the availability and the presence and participation of Thais, Karim, and Deborah. Thank you very much for joining me today. And I hope to see you all very, very soon. And thank you very much for joining you. Bye-bye.
Thank you. Bye.
Bye.
Bye, thank you.